Okay.
May I read, madam?
Yes.
This is to inform, page 15, madam. This is to inform you that on 9/7/2023 at about 8 p.m., a reliable information was received by OC Howley PS from OC Borbita PS regarding storage of 30 showcase containing heroin at the house of Hafaz Ali of Ambari under Howley PS. It is to be mentioned that on 9/7/2023 at 7 p.m., based on information received from reliable source, received by OC Borbita PS regarding dealing of drugs at Sonkosi Bazar under Borbita PS by one Ramesh Chandra Bishas. Accordingly, a GD entry was made at Borbita PS, and following the information, Ramesh Chandra Bishas was apprehended for examination from Sonkosi Bazar when he was loitering at the bazaar suspiciously.
What is your name?
My lord, I am Afaz, my lord.
Okay.
During examination, Ramesh Chandra Vishas was informed before Borpeta police that he is, along with one Afaz Ali of Ambari under Howli police station, running an illegal business of drugs, and Afaz Ali has stored 30 numbers of showcase containing heroin at his house situated at Ambari under Howli PS. Accordingly, the matter was informed to the senior official of by Borbita, OC Borbita PS, and a team headed by OC Borbita PS along with Borbita PS staff and so, along with apprehended person, Ramesh Chandra Bishas arrived at Howli PS and informed the matter to OC Howli PS. Accordingly, a GT entry was made by Howli PS number so by the OC Howli PS and informed the matter to additional SP headquarters Borpeta, placed him in a written for authority letter to authorize the undersigned so for search and seizure of narcotic drugs and psychotropic substances. Also, OC Howli PS informed the matter to Honorable Circle Officer so, Bagbor Revenue Circle, and requested him to be present for taking legal action. At which he informed that he will reach Ambari so for taking legal procedure. Thereafter, I was authorized to take necessary action against the perpetrator of law by Additional Superintendent of Police, Borbita, and accordingly, team of Borbita PS headed by so, and along with the OC Howli PS staff proceeded to Howli PS around 9 p.m. in PS departmental vehicle bearing number so, driver so, with required documents, digital waiting machine, watch, laptop, etc. for carrying out search operation as per prescribed norms. The whole police team was leaded and shown by apprehended person Ramesh Chandra Bishas. At around 9:45 p.m., the police team reached at Ambari ward number so Howli at the rental house of Afas Ali, which was shown by Ramesh Chandra Bishas. In the meantime, Bagbor circle officer also arrived at the spot. From the locality, two independent persons, namely and so who ward commissioner, were approached and they asked to be present of the search of the rental house of Hafaz Ali, on which they already agreed. The Honorable Circle Officer and his driver were requested to witness the search. At that time, Hafaz Ali was also present in that house, and I, with the help of staff, apprehended him. Accordingly, I searched the rental house and premises situated at Ambari in presence of Hafaz Ali by observing all formalities of house search and with the help of accompanied staff in presence of independent witnesses. Honorable Circle Officer and his driver and two independent and respectable person of that locality namely during search 23 numbers of plastic showcase loaded with narcotic drugs has been recovered, which were concealed by Afas Ali under the bed in his living room at the rental house. During search, the following items were recovered from the house, which were stored by the apprehended person. The recovered 23 numbers of showcase loaded with narcotic drugs were weighted by me using digital weighting machine and found the weight to be 9.88 gram with plastic showcase. The recovered 23 showcase loaded with drugs and the other recovered items, cash rupees so and so. One mobile handset were seized by me at the place of occurrence, and 23 numbers of showcase were sealed by me in 2 packets. In presence of witnesses, the seizure memo is prepared by me at the place of occurrence using laptop and printed out using printer. After completion of formalities, the police party departed from the place of occurrence, returned to Howli police station. Accordingly, the case was registered, my lord. Now, the petitioner, along with my lord Ramesh, my lord, was forwarded, my lord, on next day, my lord, page 19. On 10/7/2023. And thereafter, my lord, police also arrested another 6 persons, my lord, in connection with this case.
Yeah, then
Thereafter, my lord, after investigation, my lord, police submitted charge sheet on 29/3/2023 against all 8 numbers of accused persons. Out of 8, my lord, 7 has already been released on bail,
7 are released.
lordship. And Ramesh, my
By
lord,
which court?
one by this honorable court, my lord, is,
On what ground?
my lord, on the ground that drugs was not recovered from his possession.
Their possession. Okay. What happened to Ramesh?
Ramesh, my lord, he was also released on bail, my lord, on that ground, on page 42,
No drugs was found from his.
on that ground.
Okay. But from the house of Afaz, drugs were found.
And it was seized from the house of Afas. And now, my lord, the question, my lord, the incident took place, my lord, after 8 p.m. So 41, 42, my lord, 1 proviso 2 is mandatory, my lord.
What is this?
When, my lord, search and seizure is made after sunset, my lord, reason should be recorded.
Where? Where?
My lord,
The reason should be recorded, where it should be recorded.
why the search was made in the night, my lord?
No, whether it is recorded or not.
No.
Where?
In the nowhere, my lord, in the, and either in the search sheet or in the, my lord, seizure list.
No, what is your submission?
And
Make clearly that if the search and seizure is conducted after sunset,
lordship,
then what should be done?
a record, reason should be recorded, my lord.
For what reasons?
While search is necessary, my lord, in the night. And in this point, my lord, your lordship has decided in one case, my lord. I am referring, my lord. This is the paragraph 10, my lord. 10 and 13. 10, 11, 13.
No, no. Before we come to judgment, first let us go through the statute.
Lost.
Where it is mentioned reasons to be recorded. Proviso two,
Proviso two, my lord.
what it says. Read proviso.
That where an officer take down any information in writing under subsection one on record or record grounds for his belief under the proviso thereto, he shall within 72 hours send a copy. Proviso,
Yeah.
my lord. Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of the offender, he may enter and search building, conveyance, or enclosed place at any time between sunset and sunrise after recording the grounds of his belief.
No, he has to record grounds of belief only if a search warrant is not he is unable to take out a search warrant or authorization.
Authorization.
Here he says that I am authorized by the SP.
Yes.
What is your submission?
Authorization.
You have yourself read that in FIR he says that
He informed the higher authority.
higher authority and he authorized him to take necessary action. What is your submission on that count? You have to come with more judgments.
Second file, my lord, out of 8-7 released, my
No,
lord,
no, that will
And-
not help you because
and-
their cases are different cases.
and long
With
in,
you, well, the contraband was found in your possession. So you stand in a different footing. And those 7 were on different footings. So you cannot take benefit of that they were granted bail, therefore you have to fight your own case.
and here, my lord, after search sheet, my lord, search frame, two seizure witness examined, my lord, they have not supported the seizure, my lord. Out of 12, my lord, witnesses,
No, but others may support.
And-
There are 10 others.
seizure witness, my lord,
That will not help you. 42 second proviso may help you, provided if you come up with full
Without
prepar-
authorization.
without
Authority
authorization.
letter.
There are judgments. You come with
Look.
full preparation. Otherwise, it will be dismissed.
or should I be given chance, ma'am?
Heard Mr. R. Ali Lanet. Let him come prepared, Mr.
Yes,
Bashir.
Lord, sir. Yes, Lord.
Heard Mr. R. Ali Lanet, counsel for the petitioner. Also heard Mr. K. Bashir Lanet, additional public prosecutor. Lanet, in the midst of hearing, Lanet, counsel for the petitioner, prays that he may be given some more time so as to enable him to produce some authorities in support of his submissions. The prayer is allowed. Let this case, when do you want?
Next week, my lord. Fifth or sixth, my lord.
Seventh.
Sure.
Then this case will be listed again on. No, not 7th. Let it be on a hearing day. Okay, on 7th. 7th.
Deeply obliged.
Item number 15.
Wait, please.
Yes, what is
My lord,
this?
this is directed against an ejectment decree, my lord. Passed against me, my lord. Now, this is in fact the second round of litigation, my lord. If I may just quickly place the background, my lord.
Yes,
My lord, the respondent herein had filed a title suit, which in the way back in the year 2011. His case was that he is the owner of a particular parcel of land, which is otherwise a government land. And he said that he built two houses in that particular, he had purchased that government land by way of a Kacha deed. And he constructed two houses, one Assam type and a Tinchali house. And he further says that the petitioner before your lordship, who happens to be his brother-in-law, was let out that Tinchali house.
okay.
And then they say that we did not pay rent since 2006, and therefore title suit 65 of 2011 was instituted on the ground of default in payment of rent against me. My lord, in that particular suit of 2011, my lord, I filed my written statement and I said that in fact there is no landlord-tenant relationship here. This is all a government land. And I also have purchased a parcel of I have also purchased a parcel of the land by a Kacha sale deed, and therefore you cannot pose as my landlord. So that was the defense that was set up. My lord, eventually the trial court held that the plaintiff could not establish the relationship of landlord and tenant because the description is vague, all this is government land, and therefore, since landlord-tenant relationship is not established, the question of default doesn't even arise, and therefore, the
dismissed.
suit was dismissed.
Okay.
Against that, my lord, they went in appeal. Now, in the appeal, if I may take your lordship to that appellate judgment at page 28, my lord. If I may read from page 20.
Appeal is 47 of 2010.
Yes.
Okay.
47 of 2010. Just to indicate the respective cases, if I may just read from page 29 onwards, my lord.
Yes.
The appellant is the owner of 2 kathas of land which he had purchased from one Niresh Das in the year 1992 by executing an unregistered deed on so and so. In order to have an entrance to his land, the appellant had to purchase another plot of land, about 5 lechas in the year 1993 from one Atul Chandra Dekar. This time also the parties executed an unregistered sale deed. The appellant constructed two small Assam type houses. One was used for his own residence and the other was let out to a tenant. In fact, these two houses were Chali type houses devoid of permanent structure. In the year 1998, the appellant constructed one Assam type house and he shifted his residence to the house while his earlier Chali type residence was let out to a tenant. One of the said Chali type houses was taken on rent by the respondent in the year 1994. It may be mentioned that the respondent is actually the own brother-in-law of the appellant. The respondent was paying monthly rent up to 30/6/2006 and thereafter he stopped paying rent. This caused the appellant to ask the respondent to vacate the house. The appellant alleged that his brother-in-law conspired with his wife to grab that property. The appellant further alleged that the respondent created some situation which caused rift between the appellant and his wife. The respondent allegedly instigated the wife of the appellant to file a false criminal case against the appellant. For that matter, the appellant had to spend some days in jail also. Thus, the appellant filed the suit. Respondent's case. The respondent contested the case of the appellant by filing a written statement. The respondent claimed that he has no knowledge of the appellant has purchased land from Niresh Das. The respondent claimed that he himself had purchased 1 kotha 5 lechas of land from Vishnu Terong in the year 1990. And since then, he has been residing over the land by constructing an Assam type house. The respondent claimed that he had purchased this land prior to the appellant purchasing the land as claimed. The respondent alleged that it is the appellant who has been trying to grab his land. In this way, the entire case of the appellant has been denied by the respondent. Now, issues, there were as many as 7 issues, my lord. Issue number 3, your lordship will mark, is whether there exists any tenancy between the plaintiff and the defendant over the suit premises. And 5 is whether the plaintiff is entitled, 4 is whether the plaintiff is owner of the suit house. 5, whether the plaintiff is entitled to a decree for ejectment of the defendant from the suit premises. Now, the trial court had decided both the issues against the plaintiff and had dismissed the suit. Now, if your lordship may now come to page 37, my lord. This is the issue regarding tenancy, relationship of tenancy. Page 37, para 18, if your lordship takes up. I have carefully gone through the evidence adduced by both the parties. There is no doubt that there is no documentary evidence on record to show that the respondent is a tenant under the appellant. In spite of that, the witness Bimal Kolita, Manoj Bosho, so-and-so, supported in their evidence the respondent is a tenant. The respondent, on the other hand, instead of repudiating his tenancy in respect of the suit property, tried to establish his title over the suit land. It is true that the appellant purchased the suit land on execution of an unregistered sale deed. The respondent also purchased the land on the basis of an unregistered sale deed. In the instant case, the claim of the appellant is that the respondent is a tenant in respect of the suit property. And instead of repudiating his claim of tenancy, the respondent tried to establish his title over the suit land. Therefore, non-registration of the sale deed of respondent assumes larger significance than the non-registration of the sale deed of the appellant. Under the given circumstances, the respondent should have proved his sale deed. There is no doubt that the method of proving a sale deed has been given in section 67 of the Indian Evidence Act. The respondent did not resort to that. I have no doubt that the fact of tenancy has been proved in favor of the appellant on the basis of preponderance of evidence. The learned trial court could not agree with the case of the appellant on several grounds. One of them is that the appellant did not examine his vendor. In my considered opinion, the appellant is not required to examine his vendor because the respondent has not challenged the title of the appellant over the suit land. Under the circumstances, I failed to agree with the decision of the learned trial court. I hereby hold that the respondent is a tenant under the appellant. Therefore, the issue is decided in affirmative. Now, my lord, issue number 5 and 6, which concern, my lord, area rent and eviction, my lord, at page 39, para 22. These 2 issues are related to each other in the light of the decisions arrived at in the issues number 3 and 4. It has been proved that the respondent is a tenant under the appellant. Now, the question arises whether the respondent is a defaulter in payment of rent. I have no doubt that on this count, the appellant has miserably failed. There is no evidence on record that the respondent is a defaulter in payment of rent. Therefore, the respondent is not entitled to be ejected from the suit premises on the ground of non-payment of house rent. On the ground, I agree with the respondent that the appellant is not entitled to recover any area house rent from him. I agree with the decision of the learned trial court. I also answer this issue in negative. So it was partly reversed in the sense that the appellate court held that the tenancy is established, but then again, you have not been able to prove default, due date, etc. Therefore, the suit should be dismissed. So suit was eventually dismissed on both the forums, just that the appellate court decided issue number 3 in favor of the appellant. Now, nobody preferred any appeal against this judgment. And this judgment is not under challenge. So therefore, I'll not criticize the judgment. And in fact, we also did not prefer an appeal because the suit eventually was dismissed. So that there was no outstanding decree against me. Now, after this, my lord, this is the end of the first round, my lord.
Okay. There is another story.
Yes, sir.
Okay.
So, my lord, thereafter, at page 17, your lordship will find, I'm sorry, not page 8, your lordship will find the second suit of being TS at page 8, 65 of 2011.
Who filed this suit?
He again filed the suit.
Okay. This is a suit again for ejectment.
Again for eject. Now he says, my lord, in the suit, he narrates the earlier round and he says that given the appellate judgment, now it is established that I am the landlord and you have to not to pay rent.
No, that suit was dismissed.
This suit was dismissed.
No relief was granted.
No relief was
Only
granted.
an observation
It
made.
was made that he is the landlord and I am his tenant. So he files another suit. Again, he says that since I am the landlord, I am entitled to rent, and I will not claim the arrears until 2010 because that is covered by the earlier suit. But from 2010 onwards also, I did not pay rent despite the judgment holding me as a tenant, and therefore again I'm entitled to eviction.
Okay.
My lord, page 10, if your lordship takes up.
No, this page 8 is the second suit. 60.
Page 8 is the second suit.
What was the first title suit number?
First title suit number was 400 of 2007.
And the
Title appeal was 47
47
of
of
2010.
10. And the second suit is
Is TS 65 of 2000.
65 of 2011. Yes.
Now, at page 10, if your lordship takes up, here he narrates the earlier round of litigation. And at para 8 onwards, he says that the judgment was delivered by the appellate court on 29/11/2010. Thereafter, the plaintiff demanded the house rent on 5/11/2010 from the defendant. The defendant is fully aware of the finding of the appellate court to the effect that the appellate court has held him to be a tenant under the plaintiff. The defendant was requested by the plaintiff to pay house rent at the rate of rupees 300 per month, as he used to pay earlier, but the payment of house rent was stopped with effect from 30/6/2006. Thereafter, the suit was filed in the month of July 2007 for ejectment of the defendant from the scheduled house and for realization of area rent of rupees 3,600 from 1/7/2008 to 3/7/2007. But the suit was dismissed. The house rent for the said period from so-and-so to so-and-so, as well as the period from so-and-so to so-and-so, that is the date of judgment of the appellate court, remain unrealized. Since the plaintiff failed to prove the default as held by the appellate court, he gave up the claim for the said period. However, after the judgment of the appellate court, that is after 29/11/2010, the defendant had to pay the monthly rent of the scheduled premises at the rate of rupees 300 per month regularly, but the defendant failed to pay the house rent to the plaintiff for the month of December 2010 and January 2011, in spite of the demand. Rather, the defendant refused to pay the monthly rent to the plaintiff. Thereafter, the judgment dated 29/11/2010, the rent for the month of December 2010 became due on 1/10/2011, and for the month of January 2011 became due on 1/2/2011, and the defendant was liable to pay within fortnight of its falling due, but he failed to pay in spite of the demand. Thereby, the defendant has become a defaulter in payment of the house rent for the month of December 2010 and January 2011. So, for the subsequent period post the date of judgment, the respondent yet again claims eviction on the ground of defaultment. Now, we filed our written statement, my lord. We again denied the fact that they are actually not the tenant. And we said that since the appeal was otherwise decided in our favor, that judgment will not come in the way of deciding whether I'm actually a tenant or not. And therefore, we prayed for dismissal of the suit. Our written statement, your lordship finds at page 44, my lord. Para 9 at page 45, your honor.
Yes.
We again denied the jural relationship of tenancy. And in fact, at page 14, we had again claimed that we had actually purchased a parcel of lands. So all of this is government land. Nobody has title deeds. So we say, that we purchased by a kacha sale deed, and they also say they purchased by a kacha sale deed. So other than those kacha sale deed, there is no document of title, so to call.
Yes.
Then, my lord, the trial court this time again dismissed the suit, my lord.
There is
That page 51 is the trial court judgment of TS 65 of 11. Now, first of all, if your lordship takes up page 54.
Yes.
54, your lordship will find there were 4 issues framed this time, my lord. And despite the plea taken by me in the written statement, there was actually no issue concerning the relationship of landlord and tenant this time.
Okay.
Now, the suit was nevertheless dismissed, my lord, on the ground
What ground?
that they could not prove default.
Defaulter.
Page 59. Because there were no rent receipts, nothing, no agreement, absolutely no documentary evidence. And at page 59, the trial court held if I may read the second paragraph at page 59. Lord.
Yes, yes.
The main plea taken by the plaintiff for ejectment of the defendant is default in payment of rent. There is no evidence on record to establish the fact that the defendant is a defaulter in payment of rent. The evidence of the plaintiff are nowhere connected with the issue of default in payment of rent. Therefore, the defendant is not entitled to be ejected from the suit premises for his default in payment of rent for the months of December 2010 and January 2011 under the Assam Urban Areas Rent Control Act 1972. The evidence adduced by the plaintiff doesn't contain any significance that the defendant has defaulted in payment of rent. Therefore, he is liable to be ejected, and there is no question of recovery of area rent. My lord, this time, again, they go up in appeal, and the appellate judgment, your lordship finds at page 62. Now, my lord has already seen the issues. The one issue which covers the entire dispute is issue number 2, whether the defendant is a defaulter in payment of rent. Now, page 67, if your lordship turns. '67, as your lordship.
Yes,
Para 17 onwards.
yes.
I have perused the Exhibit 7, copy of the judgment passed in Title Appeal 47 of 2010, dated 29/11/2010. It has been clearly mentioned in Para 20 of the said judgment that the defendant is a tenant under the plaintiff. Defendant in his cross-examination as DW1 has stated that he has accepted the judgment passed by the appellate court in Title Appeal 47 of 2010, meaning thereby he has not challenged the said judgment of the learned trial appellate court. Defendant also has not challenged the impugned judgment, holding that he is a tenant under the plaintiff by preferring any cross appeal. Therefore, established position in this case is that the defendant is a tenant under the plaintiff. Para 18, when the landlord-tenant relationship has been established by evidence on record, it appears to me that it is for the tenant to show that he is not a defaulter in payment of rent. In the instance suit, the plea of the defendant is that he did not pay the rent to the defendant since he is not residing in the house of the plaintiff and is residing in his own house, and he is not a tenant under the plaintiff. Therefore, admitted position in this appeal is that the defendant did not pay rent in respect of the suit premises to the plaintiff. Plaintiff in his evidence categorically stated that the defendant used to pay rent in respect of the suit premises up to 2006, but thereafter he stopped paying rent to him. Plaintiff has not claimed rent in respect of the suit premises for the period in which the earliest suit and the appeal were pending. However, he has categorically stated in the evidence that thereafter defendant has not paid rent from 1/12/2010 to 31/1/2011, amounting to rupees 600. when the tenancy has been established, an admitted position is the tenant has not paid rent to the landlord. Certainly, he has become a defaulter, making him liable to be evicted from the suit premises. Therefore, the decision of the learned trial court is found to be not based on record, and the same is liable to be reversed. Accordingly, it is held that the defendant is a defaulter in payment of rent. The issue is answered in the affirmative. So, my lord, the reasoning cited by the appellate court is basically this, that tenancy otherwise is established and you have nowhere claimed to have paid rent. So therefore, naturally, you are a defaulter. My lord, my limited ground here is this one. My lord, to arrive at that finding, the appellate court presupposed that there is a jural relationship of landlord and tenant between the parties. And the only basis to hold that I am a tenant under him is that finding that was recorded in title appeal 47 of 2010. And the first appellate court goes further to say that since you did not challenge that particular judgment, so therefore this is binding upon you, therefore probably drawing the rule of res judicata and saying that now it is too late in the day for you to say that you're no longer a tenant since you did not challenge the judgment in title 47 of 2010. Well, the moot fallacy in this point is to ask the question whether I could have preferred an appeal against title appeal 47 of 2010. Now, it has been laid down in a catena of judgments that for a person to prefer an appeal, there has to be a decree against it, because there is no provision of an appeal against a mere finding. Of course, if they would have challenged, I could have preferred a cross objection. That's a different matter altogether. But if they don't prefer an appeal, I cannot go before the appellate forum to merely challenge a finding. Okay. Because neither 96 nor 100 contemplates appeal only against the finding. This was established long back in the case of Gangabai, my lord. (1974).
Yes.
Reported in 1974 to SCC 393. This is Gangabai versus Vijay Kumar.
Which para?
Paragraph 15, if your lordship takes up. 1974 to SCC 393. To SCC 393. Para 15, my lord. SCC. It is thus clear that the appeal filed by the defendant number 2 and 3, SCC 393. It is thus clear that the appeal filed by the defendant number 2 and 3 in the High Court was directed originally not against any part of the preliminary decree, but against a mere finding recorded by the trial court that the partition was not genuine. The main controversy before us centers around the question whether that appeal was maintainable. On this question, the position seems to us well established. There is a basic distinction between the right of suit and the right of appeal. There is an inherent right in every person to bring a suit of a civil nature, and unless the suit is barred by statute, one may at one's peril bring a suit of one's choice. It is no answer to a suit, however frivolous, to claim that the law confers no right to sue. A suit for its maintainability requires no authority of law, and it is quite enough that no statute bars the suit. But the position in regard to appeals is quite the opposite. The right of appeal inheres in no one, and therefore an appeal for its maintainability must have clear authority of law. That explains why the right of appeal is described as a creature of the statute. Para 16 thereafter. That explains why the right of appeal is described as a creature of statute. Under section 96(1) of the Code of Civil Procedure, save where otherwise expressly provided by the code or by any other law for the time being in force, an appeal lies from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. Section 100 provides for a second appeal to the High Court from an appellate decree passed by the court subordinate to the High Court. Section 104(1) provides for appeal against other orders of the kind therein mentioned and ordains that save as expressly provided by the court or by any law for the time being in force, an appeal shall lie from no other orders. Clause I of this section provides for an appeal against any orders made under rules from which an appeal is expressly allowed by the rules. Order 43(1) of the code, which by reason of clause I of section 104(1) forms a part of that section, provides for appeal against orders passed under various rules referred to in A to W thereof. Finally, section 105 of the code lays down that save as otherwise expressly provided, no appeal shall lie from any order made by a court in exercise of its original or appellate jurisdiction. These provisions show that under the Code of Civil Procedure, an appeal lies only as against a decree or against an order passed under the rules from which an appeal is expressly allowed by Order 43, Rule 1. No appeal can lie against a mere finding, for the simple reason that the court does not provide for any such appeal. It must follow that the first appeal number so-and-so filed by the defendant number 2 and 3 was not maintainable as it was directed against the mere finding recorded by the trial court.
Then
So, my lord, insofar as that finding is concerned, I could not have preferred an appeal. Because the decree was otherwise in my favor, their suit was dismissed. So far as
now,
that.
what is the effect of that finding?
My lord, now, my lord, again, the Supreme Court had the occasion to see that what happens if I can't prefer an appeal, can that finding be a res judicata against me? Now, there again is the judgment of Devaram and another. This is 1995, 6 SCC 733. 6 SCC 733.
1995.
Para 25 onwards, man. Now, let us consider the plea regarding the effect of an adverse finding recorded by a court against the party in whose favor the suit or appeal is ultimately decided.
You are reading para?
25. Page 740.
Okay.
25.
Yes.
Let us now consider the plea regarding the effect of an adverse finding recorded by the court against the party in whose favor the suit or appeal is ultimately decided. It is provided in section 96 that an appeal shall lie from every decree by any court exercising original jurisdiction to a court authorized to hear appeal from the decision of such court. So also section 100 provides that an appeal shall lie to the High Court from every decree passed in appeal. Thus, sine qua non in both the provisions is the decree, and unless the decree is passed, an appeal would not lie under section 96 nor would it lie under section 100 of the CPC. Similarly, an appeal against an order under section 104, read with 43(1) of the CPC, where the orders against which appeal would lie have been enumerated, unless there is an order as defined under section 214, and unless that order falls within the list of orders indicated in order 43, an appeal would not lie. Thus, an appeal does not lie against mere finding recorded by a court, unless that finding amounts to a decree or order. Where a suit is dismissed, the defendant against whom an adverse finding might have come to be recorded on some issue has no right of appeal, and he cannot question those findings before the appellate court. In Midnapur Zamindari Co. versus Naresh Narayan Roy, it was observed as under. Their lordships do not consider that this will be found an actual plea of res judicata for the defendant. Having succeeded on the other plea, had no occasion to go further as to the finding against them. But it is the findings of a court which was dealing with facts nearer to their kin than the facts are to the board now. and it certainly creates a paramount duty on the appellants to displace the finding, a duty which they have now been able to perform. Similar view was also expressed in an earlier decision in so and so. The Aoudh Chief Court in Pateshwari Din versus Mahan Sarju Das held that where a decree in a previous suit is wholly in favor of a person and gives him all the relief sought by him, he has no right of appeal against the decree so as to enable him to contest any adverse finding against him in such suit. Hence, such adverse finding cannot operate as res judicata against him in a subsequent suit. The High Court of Andhra Pradesh in so and so, the full bench of the High Court of Patna in Arjun Singh versus Taradas Ghosh have taken the view that an appeal would not lie against mere finding unless such finding would constitute res judicata in the subsequent proceeding. We are not concerned with that aspect of the matter in the present case, nor are we concerned with the earlier aspect, as the plea of res judicata have not been raised in the written statement. So basically, my lord, since I could not have challenged it, my lord, to hold that finding would be binding on me for all times to come. On one hand, there is no remedy of an appeal, or there is no forum for me to challenge that finding. And on the other hand, if the principles of res judicata are imported based on that finding, my lord. So therefore, now given all of this, my lord, the moot problem arose because of the fact that they did not formulate an issue. Perhaps under the misconception that since the issue regarding tenancy is already decided in the earlier round, therefore no issue is warranted insofar as the second suit is concerned. My lord. Now, if that issue, that finding goes, my lord, and if the finding is held to be not binding upon me, that is the moot issue in any landlord-tenant relationship, whether there is a dual relation of tenancy or not. So
Now, whether that finding is binding on you or not.
my lord, which finding? Of 47?
47, that you are
Yes.
tenant. 47, civil appeal 47 held that
And it,
the respondent is your landlord.
yes, my lord.
Is the landlord in respect of that
Yes,
Sali
yes.
house. Now, till now you have argued on the question that you were not left with any remedy because the suit was dismissed, appeal was dismissed. So you could not have preferred any appeal.
And since I could not have preferred an appeal, my lord, therefore the principle of res judicata was
Is
not
not-
operating.
Yes. Now, okay. Therefore, you can re-agitate
I
that.
will re-agitate and the court is bound to consider.
Okay.
And that is where I say that has been a jurisdictional error because,
So you in your WS, though you took this plea,
my lord,
no issue was framed
no issue was framed.
regarding the
No issue was framed.
court-
And insofar as the first
court,
appellate-
in the second round of litigation,
yes,
as the court observed that the issue has been settled by 47,
correct,
it framed no issue.
Correct.
Okay.
correct. And otherwise, there was because my lord had seen the factual background, my lord. There is a matrimonial dispute, brother-in-laws fighting amongst themselves. There's absolutely no document to establish superior title of either of the parties. Both are claiming on the basis of invalid unregistered deeds, my lord.
Now, what is your submission that in the second round of litigation,
Right.
the appellate court
Ought to have taken into consideration my plea, ought to have discussed the evidence. Not initially, the trial court should have ideally framed an issue. The parties should have been given the opportunity of leading evidence on that issue. Now, let us for a moment assume that non-framing of the issue is not fatal. But be that as it may, the appellate court has based its finding only on that point. Your lordship has seen that default, otherwise they could not prove due date for fortnight payment, etc. Now, appellate court, of course, that reasoning otherwise may appear sound. That since I do not admit my tenancy, where is the
but
question?
you are raising a claim that I am myself the
Correct. So those aspects were not even gone into, and the first appellate court appeal is a valuable right, which the appellate court can decide both on law and facts, and that particular factual aspect regarding whether there is a relationship of landlord and tenant that was never decided. And in fact, it has been held by many judgments, my lord, that is the first issue that you ideally ought to decide in any landlord-tenant dispute, whether there is a tenancy. Then comes the default, bona fide requirement, whatever be. And in fact, my lord, one of the judgments, my lord, this honorable court had even remanded a matter where there were no findings regarding that tenancy part, you know.
No, there is a finding. in
There
the-
is a finding based on the earlier judgment. my
Without
lord.
issue.
No.
Without framing an issue,
Yes,
in the instant case, though no issue was framed,
there is a
but
finding.
there is a finding that you are a teen.
Tenant, and that finding is not an independent finding based on the evidence on record in
So
the
your
court.
submission is you were not afforded with the opportunity of leading evidence
My lord,
on that finding.
my lord. That and that apart, my lord, the finding that was ultimately rendered was based on an earlier judgment which could not have been given the ratio laid down by the Supreme Court, that those findings, adverse findings recorded in an earlier suit, where the decree itself is in my favor, will not operate as a res judicata.
What is your submission on the finding in the uh, Civil Appeal 47?
47, my lord, is not under challenge, my lord. Otherwise, my lord,
No, you have to somewhere you have to challenge it.
Correct.
Not 47,
Correct.
but the ground, the ultimate finding that you are the tenant.
my lord, that 47 judgment, if your lordship sees, 47 judgment had basically said, my lord, that both have unregistered sale deeds. But
So what is the definition of landlord?
landlord, anyone who's entitled to receive rent is a landlord.
So even if he is not the owner of that land.
Correct. In fact, there have been instances where it has been held that title should not be gone into.
Okay.
But fact of the matter is he must establish some jural relationship. Had it been an admitted position, there was no difficulty. The appellate judgment is perfectly sound that I did not pay tender. I did not claim to have paid rent, so naturally I'm a defaulter. But here is a case where the tenancy relationship of tenancy was my lord, disputed. And from this, if I may, I'll just take your lordship back to that judgment of title appeal 47, my lord. Now, this is reported in 2007, 3 GLT 182. Para 10 of that judgment, my lord.
Yes.
A careful reading of the points which the learned first appellate court had formulated for its decision clearly indicates that what the learned appellate court attempted to ascertain or determine was as to whether the plaintiffs had title to the suit property and whether it was the defendant who had the title thereto. There was in fact no attempt by the learned appellate court to determine if there existed relationship of landlord and tenant between the parties concerned. Be that as it may, having considered the evidence on record, the learned appellate court observed from the evidence adduced by the contending parties, I do not find any material that shows that the appellants are tenant of the respondent within the meaning of the Assam Urban Areas Rent Control Act, so the question of defaulter does not arise. This point was decided in favor of the appellant. From a careful reading of what has been observed with the learned appellate court, it becomes transparent that the learned appellate court has concluded the plaintiffs could not prove the defendant and was a tenant under them within the meaning of the word tenant under the Assam Urban Areas Rent Control Act, and hence the question of the defendant having become a defaulter does not arise at all. Having reached such a clear finding, the learned appellate court could not have come to concluded that the plaintiffs were entitled to the decree. The entire approach of the learned appellate court is thus contrary to law and devoid of any logical application of mind. If the conclusion so reached, the judgment so delivered allowed to stand good on record, it will cause miscarriage of justice. It is clear from a careful reading of the observations made by the learned trial court that no attempt was made by the learned trial court to determine if there existed a relationship of landlord and tenant between the parties concerned, nor was there any specific issue framed by the learned trial court in that regard. The learned trial court, while deciding issue 7 and 9, 8 and 9, observed and concluded as under plaintiff's contention is that defendant came to the suit premises as a monthly tenant in the year 1988 on an oral arrangement to pay monthly rent of rupees 200 per month with condition that he shall quit and vacate the premises as in when asked, but denying the ownership of plaintiffs completely. Defendant has claimed the title of the suit premises on his own right through gift alleging to be made by so and so the grandfather of the plaintiff and also through adverse possession. So the burden of the case has been shifted to the defendant to prove his right of occupation of the suit premises. But it is seen that the defendant has failed to prove it. As such, it infers that the defendant came to the suit premises as tenant as claimed by the plaintiff. But the defendant has denied the tenancy under the plaintiff and payment of rent to the plaintiff. So definitely defendant is a defaulter in payment of rent since 1997 as alleged by the plaintiff. However, in my view, due to non-production of account of rent, plaintiffs will not be entitled to arrear of rent. From what has been observed above by the learned trial court, it is clear that the learned trial court has merely stated the case of the plaintiffs and then abruptly concluded the defendant was a defaulter. There is absolutely no discussion as to how the plaintiffs were regarded as landlord of the defendant. Because of what has been discussed and pointed out above, neither the learned trial court nor the learned appellate court addressed the moot point for decision, namely as to whether the relationship of landlord and tenant existed between the plaintiff on one hand and the defendant on the other. Though the plaintiffs had taken the ground of bona fide requirement, no issue was framed. However, in view of the fact that plaintiffs did not file any appeal against the learned trial court judgment and decree, it is no longer required for the trial court to determine if the suit premises are bona fide required by the plaintiffs as landlord. Considering, therefore, the matter in its entirety, and in the interest of justice, the impugned judgment and decree dated so and so and the judgment and decree dated so and so are hereby set aside. The suit is remanded to the learned trial court with a direction to frame an issue on the question as to whether the defendant is a tenant under the plaintiff in respect of the suit premises, and then further determine as to whether the defendant was a defaulter and whether the plaintiffs are entitled to the decree as had been sought for. So
In the-
barring Exhibit 7, Manoj, there was absolutely nothing on record, Manoj.
What is exhibit 7?
Exhibit 7 is the appellate judgment.
Okay. What,
Now,
let me put one more query.
Malay,
In title suit number 400,
Malay,
the first original title suit,
Malay.
the issue was framed regarding the relationship of tenants. How that issue was decided?
Malay, that issue, that finding is also vulnerable in the sense, my lord, if your lordship takes up that issue, my lord, that issue is page 37, if I'm not wrong. 37. I had once read it, my lord. This was also, my lord, with utmost respect, not very conclusively dealt with, you know. Page 37, para 18. I have carefully gone through the evidence by the parties. There is no doubt that there is no documentary evidence on record to show that the respondent is a tenant under the appellant. In spite of that, the witnesses Bimal Kolita, Manoj Basho, Joy Charan Kolita, and Tonkeshwar Phukon supported in their evidence that the respondent is a tenant under the appellant. The respondent, on the other hand, instead of repudiating his tenancy in respect of the suit property, tried to establish his title over the suit land. Just to pausing here, Malad, he had repudiated the tenancy. He had repudiated the tenancy on the ground that he himself is the owner. It is true that the appellant purchased the suit land on execution of an unregistered sale deed. The respondent also purchased the
No, we
land.
can, by claiming title over the suit land,
Malad,
he is in fact repudiating, he is in fact saying that I am not the tenant. Tenant.
Yes, exactly. It is true that the appellant purchased the suit land on execution of an unregistered sale deed. The respondent also purchased on the basis of an unregistered sale deed. In the instant case, this is important, my lord. In the instant case, the claim of the appellant is that the respondent is a tenant in respect of the suit property. And instead of repudiating his claim of tenancy, the respondent tried to establish his title over the suit land. Therefore, non-registration of the sale deed of the respondent assumes larger significance than the non-registration of the sale deed of the appellant. But with utmost respect, I fail to find logic in this, my lord. He said, therefore, since I am also claiming title, Therefore, non-registration of the sale deed of respondent assumes larger significance than the non-registration of the sale deed of the appellant. Under the given circumstances, the respondent should have proved the sale deed. There is no doubt that the method of proving a sale deed has been given in section 67 of the Indian Evidence Act. The respondent did not resort to that. I have no doubt that the fact of tenancy has been proved in favor of the appellant.
Okay, okay. No, the earlier question which I posed, what is the definition of landlord in,
No, no.
read again.
Landlord means any person who is for the time being receiving or entitled to receive rent in respect of any house, whether on his own account or on behalf of
Receiving or entitled to
receive rent.
the rent in respect of
In respect of any house,
any house.
whether on his own account or on behalf of or for the benefit of any other person as a trustee, guardian or receiver for any other person, and includes in respect of his subtenant a tenant who has sublet the house, includes any person not being a tenant who from time to time derives title under a landlord. Now, my lord, the definition of tenant is again given as tenant means a person by whom or on whose behalf rent is payable for any house and includes every person who from the time to time derives title under a tenant. Now, my lord, I have not brought them, my lord. In fact, this when the deciding burden of proof, my lord, our high courts have held that the initial burden is always on the landlord to establish the landlord-tenant relationship. Now, the moment the landlord-tenant relationship is established, my lord, and landlord alleges default, my lord, then the burden shifts on the defendant to prove that he is not a defaulter. And he has to show either by receipts or deposit in the form of NJ cases that he is not a defaulter. If I'm not wrong, my lord, that was what the full bench judgment of Kalikumar Sen had said. Now, so therefore, sequentially, if we see, my lord, it is for him to establish landlord-tenant relationship rather than for me to establish title so as to dislodge his claim of tenancy. That is where, in my humble understanding, my lord, the appellate judgment in Title Appeal 47 of 2010 can also be faulted with. But without going into that aspect also, my lord, even assuming that there is a unchallenged clear finding, my lord, when the decree itself is in my favor, ultimately it doesn't operate as well.
You can raise it in
Even
a subsequent proceeding.
Yes.
So your main submission is that issue ought to have been framed in,
It had ought to have been decided independently without taking aid of the earlier judgment, my lord.
in both the subsequent title suit as well as title appeal.
Yes. And then, my lord, the question of default should have been, because your lordship has seen that the appellate court does not really go into clear findings whether there is a default or not. So if that initial finding goes, the finding regarding default also goes. My lord has seen the appellate court's finding, my lord. I just
It has based on its finding on the premise that as you are plaintiff, as you are tenant, and as you have said
that I'm not a tenant.
I'm-
That means that you
you have not paid.
So therefore, if the first finding goes, my lord, then the default part again has to be looked into. So, in fact, my lord, I would suggest, my lord, if your lordship can exercise the power under Rule 25 and frame an issue and then remand it back, because that's ultimately the moot issue, my lord. Actually, your lordship has already seen, my lord, these are all government Katoji khas land, my lord. He claims that I am the owner and that is how I get the right to induct a tenant, which I eventually did by inducting a brother-in-law. The several facets of matrimonial dispute between the husband and the wife, and that is how, my lord, he claims to have.
Okay. Anything else?
My lord, I'll reserve my right of reply after I hear my friend, my lord.
Yes, Mr. Upadhyay.
May Allah. Yeah, my lord, my learned friend argued that the judgment of the learned trial court based on the finding recorded in the earlier suit,
Earlier appeal.
earlier appeal, finding recorded in the earlier. It is not so. Your lordship will see that judgment Yes, it is a correct that the issue, the issue, second issue, whether the defendant is a defaulter, yeah, the issue regarding the relationship of landlord and tenant was not same. But under the issue number 2, your lordship will see it is a very elaborate judgment. It is a very independently appreciated, your lordship, the entire evidence. And thereafter come the finding. It
Judgment
is
of
not that
the-
earlier there was a finding and on the basis of that finding, learned trial court gave its judgment. It is not so. At all not correct. Your lordship will see the judgment. Judgment, your lordship will find the page number 51. Page number 51, very elaborate judgment. Here, in fact, the my cell deed and their cell deed, my cell deed, so far my cell deed as concerned, my lord, the two cell deed were written by the defendant himself, yes, appellant himself, my cell deed, so far my,
No, no, I'm not getting you.
yes.
Your sale did what?
When I purchased the land, main, in part by part, I had purchased. So far my, here, all these things are here, my.
No, whether government land can be purchased. These are different
No,
other
possessory right
questions.
can be purchased, possessory right, not a title, there is no question. of
Here
title.
we are concerned only with landlord-tenant
Yes,
relationship.
yes. Your lordship will see the judgment of the trial court. 51,
Yes, where?
There's number.
51.
51,
That's
a
a trial court judgment.
trial court judgment,
Of 65.
51
51 of title suit 65.
Yes.
That is the section.
title suit.
Yes.
Now, you
That
start
he
with
has
the
read
relevant
the-
portion, start issue number 2, whether is a defaulter, because this issue, my learned friend argued that no issue was framed regarding the relationship of landlord tenant, but under this issue, the entire subject matter was discussed under this issue number 2, whether the defendant is a defaulter. Your lordship will see, I read. May I read, ma'am?
No, when you frame that issue that whether defendant is a defaulter,
No.
then
It also dealt with the.
it appears that you
relationship
have
of-
already,
Dealt with the relationship of landlord and tenant.
No,
under this
no.
issue.
before, I have not gone into,
My lord.
when you frame an issue, whether defendant is a defaulter without framing an issue regarding relationship of landlord and tenant,
No,
it appears that
in my
the court
opinion,
has presumed
Yeah.
that
can be,
such a relationship exists.
yes, for the
But,
framing of the issue,
No,
not a
no,
fatal,
but-
your lordship.
but in the view of the fact
Default
that
of when a person. There is settled law, it is a settled law, my lord. If necessary, I shall show the judgment. Today, but I have not brought that judgment. In earlier round of argument, my learned friend, that issue was not raised.